सर एम्प्लॉयमेंट लॉज के अंदर एक एम्प्लॉय जब मिसकंडक्ट करता है तो व्हाट आर द रेमेडीज एंड व्हाट आर द वेज दैट कैन बी शुड बी टेकन बाय एन एम्प्लॉयर?
देखिए मिस्टर बिपुल मिश्रा, you yourself know quite a lot, but thank you very much that you are asking some questions which are basic questions, but this will be very useful for the new companies which are coming and sometimes they face these problems. This is well known thing that departmental and domestic inquiry is basically what? It is only departmental means it is an internal inquiry. That is why it is called domestic inquiry.
Sir,
if anybody commits any kind of a misconduct, so I think you should ask a question, what is misconduct, because these all are relevant. So we have got a limited time, but we will give the basic informations that if somebody is doing a misconduct which falls under the service rules or standing orders. What is standing orders, what is service rules, which you can ask in the next video, rather even now you can ask. So the charge sheet is issued, and the charge sheet means you are putting certain charges for misconduct, that you have slept on duty or you have not come. This is called charge sheet. Charge sheet should be elaborate, it should not be too brief, because it has been seen that sometimes people just put the charges which are not very clear. So if the charges not very clear, because those charges have to be proved in domestic inquiry. So if the charges are not clear, then the evidences, then the inquiry, and then the argument will not go very clearly. So in my view, the charges should be very clear, because which I think I am little bit talking something from my side, because experience is too large, which is 35 years, not only on the matters of employment laws, but at the level of Supreme Court. So I know what is the concept of a dispute. After any dispute arises, the judge has to see at the apex court that what is the justice to be imparted. So until you are able to convince him that the charges were proved, you will not hold good at the later stage. So it starts that your charge sheet should be very clear and in detail, so that that can be properly examined.
Sir, in this conversation you talked about the misconduct which comes under the service rules and as per the Standing Order Act. If any act which is not there in either in service rule or in Standing Orders Act, then whether that act will come under the purview of misconduct or not?
This is a very technical question which you are asking, that any act committed by a person, like a moral turpitude. Moral turpitude is one of those kind of acts which you are talking about, which has not been given either in a standing orders or in service. Will it constitute misconduct? If it is not a misconduct, you can't do a domestic inquiry. So whether it is a misconduct, you see what is misconduct. Normally, if you go at a lower stage, then they go word by word, that well, it is not given in a misconduct. Misconduct is basically a thing the person and an employee should be governed and should keep the decorum and do the things which are not unlawful, which are in the eyes can be justified. So even if something is not being mentioned in the standing order, in my view, and we can prove it at a later stage, like moral turpitude, you will find it has not been given. That means you can't morally, somebody is doing some wrong thing. I don't want to talk on the video here. There are many sexual activities which sometimes cannot be proved in a moral turpitude, going out of the purview or falling into the purview. Then that can also be the misconduct. So I think you got your answer. Only we have to justify and explain.
To summarize this, I can say that the acts which are not in a good sense can also be a misconduct, whether it is there in the rules or not.
Yes.
Like it was said in the Jyoti Laboratory case, that a misconduct per se is also a misconduct. An act which is subversive of discipline, which is not to the good conscience, is also a misconduct.
Mr. Mishra, I think we are going very technical, but since you have raised this point, I would like to make it clear. Whenever I see, I have practiced in the lower court, in the tribunals, I have practiced in High Court, not that much in High Court, but Supreme Court definitely I have done a lot. And what I have observed in Supreme Court, this is only you have to prove the judges, because that is the apex court. They don't follow the judgments of the high courts. They follow the judgments, they are governed by the judgments of a larger bench, which normally is not there. So they see what is the justice. You have to see what is, if a man of ordinary prudence, suppose you are a judge, you have to see what is right and what is wrong. Because
Sir,
these judgments what you are referring, if it is not Supreme Court, it doesn't make a difference in Supreme Court at all. I have seen Mr. Jetley arguing with one of the bank's matter. I was there and Mr. Jetley was there, and I was thinking that this is a matter of, I am just talking, I think we are going to a very, very deep in the senses of the law, that how is law important. Let us come back to the main, because this will be helpful to the people who are starting and opening new industry. This is not for the lawyers, but your points, let me complete. So you should keep the judgment which you are referring after, what is the intention to impart the justice only. So we have to see what is the justice, how much we can prove, how can we satisfy to the court, because they are not governed by the judgment. If they are convinced that this is something wrong, this is a moral turpitude, then you will get the judgment. So the judgments can always differ in circumstances, can always be overruled also. So let us not only, of course, at labor court and high court those things will matter, but at Supreme Court level, where if the matter is deep, it will go to that extent, and you should keep this thing in our mind that we have to convince to the court that what is the justice. These judgments will not matter much.
sir, so the first thing would be misconduct, then issuance of charge sheet, and after issuance of charge sheet, what are the things to be done by a management against the employee who has done this misconduct?
You see, it is very simple. I think let us go on a basic, then in next video we will go a little more technical, which will be helpful at a level of the Supreme Court also. So let us not go there. The basic questions as you are asking now, one is this, that when the charge sheet is given, the charges you impose, that have to be proved by the management. So the simple procedure is this, that one management representative will be there who will represent the management representative, and similarly the opposite party should also be allowed to be represented by his representative. Now the questions are technical questions. Again, sometime what happens, what I have seen, I am a little bit going one step ahead of you. Sometime lawyers come, management bring the lawyer, and opposite party says that he is not having a lawyer, then the lawyer should not be allowed, because again it becomes imbalance. Again I said the same thing, we have to see what is the balance, what is the man of ordinary prudence decide to impart the justice. That's what we have to see. So if there is a lawyer and you don't have a lawyer, naturally the balance of power will be disturbed. So there should be, other person should also bring a lawyer, so that it should be equalized, and you can bring your representative, management representative, and then the inquiry will proceed. The witnesses of both sides should be one by one come. Suppose it is a management, this also kept on turning many times. Sometime management evidence used to take first place because they have put the charge. Sometime it was the workman evidence, but that is not the question who will go first. That may depend on the recent judgments. But what I am trying to say, management put his witness, one witness is giving his gave the examination in chief, then other person should not be there. Of course these days on video this element is disturbed, because you don't know who is standing on your back. But otherwise this is a principle that one man is when giving in evidence, the other witness should not be there, so that he should know. Why? Because if there is a contradiction, later on you can see that the same incident cannot be repeated in the same way. So there will be a contradiction in the witnesses.
Okay,
you get my point? You get my point?
Yes, sir. Thank you.
So I will also again just finish it up. So that is the evidence, both sides, then cross-examination. Then after that, on the basis of this, the inquiry officer furnishes the
Inquiry report. Thank you, sir. That was nice talking to you, and it was I hope it will help the others. They will be helped by your knowledge and expertise. Thank you, sir.
एक बात बताएं,